Hello, I'm Morgan Peckma, Editor-in-Chief of City and State, and this is Last Look. Today, our guest is Laurence Laufer. He is an election law attorney and a partner at Genova, Burns, Giantomasi, and Webster. Laurence, thank you so much for joining us.
Thank you for having me, Morgan.
Among your many clients is Mayor-elect Bill de Blasio. Were there any unusual election law situations that arose in the course of the primary or the general election?
Well, we represent the campaign primarily on campaign finance compliance, and the de Blasio campaign did very well in terms of qualification for public matching funds. So I would say that on that front it was probably a smoother ride as the election turned out to be. On
the election law front, it seemed like the biggest story of the year actually had to do with Bill de Blasio's ultimate opponent, Joe Lhota, in regard to a PAC that supported him. And the Second Circuit ruled in favor of that PAC. Could you talk about what that decision is?
Well, the decision concerned New York state law as opposed to New York City public financing system. And under state law, there is an overarching $150,000 limit that applies to the amount that persons can give to political committees throughout New York State. It's an annual limit. And the action that was brought and I think the PAC is called New York Progress and Protection, really follows a pattern that we've seen around the country after the Citizens United case. And the specific challenge is the notion that since this PAC was claiming to just engage in independent spending, meaning they didn't coordinate with the Lhota campaign, they were just independently looking to support him, that they argued that that $150,000 limit could not be applied to the funds raised by the PAC. The fellow who was purportedly financing the PAC, his name is Sean McCutcheon, an Alabama businessman who pledged to give $200,000 if the federal courts would rule that the New York State $150,000 limit was unconstitutionally to be applied to that PAC.
And so that the court didn't say that he could do it, but it said that it was likely that this would prevail, this case would prevail, and so they didn't stop him from being able to donate that money, and David Koch ended up putting $200,000 into that PAC, I believe. And so what are the larger implications for New York State of this ruling?
Well, in the broadest sense, what has happened since Citizens United around the country and coming now to New York is people should get familiar in the campaign finance realm with the notion that there are really two universes, a limited universe and an unlimited universe. And depending on what you want to do in relation to an election, you're going to fall into one of those other classifications. So for example, if you want to support a candidate by directly contributing to their campaign to enable the candidate to spend the money on television advertising or what have you, you're going to be subject to contribution limits. There are limits that apply under state law, there are limits that apply under city law. And the notion of these contribution limits, I mean, it's well grounded in Supreme Court jurisprudence that the idea of a limit is to curb the potential that anyone could corrupt or appear to corrupt the recipient. But in the case of independent expenditures, and again, this is what really the momentum was created by Citizens United, the Supreme Court has said that those don't have the potential to corrupt a recipient because the recipient is an independent spending entity. It's either you can spend directly to support the candidate, in which case there's no quid pro quo there, or you can give to an organization, and these have now commonly called super PACs, that can independently support the candidate. So what the Supreme Court and circuits throughout the country have now settled, and the Lhota PAC case has brought it to New York, is that somebody who wants to support a candidate independently can give to a super PAC dedicated for that purpose and avoid application of what was a $150,000 spending limit. That's the gist of the Second Circuit decision. They've indicated that's likely to succeed on the merits as the case plays out.
Where's the line drawn for not having coordination with independent expenditure. I mean, it oftentimes seems like this is just like a pretense for the sake of legality. I mean, we saw during the presidential campaign in 2012, Newt Gingrich walking out of a meeting with Shelley Adelson being like, oh, you know, this guy's running my IE, have nothing to do with that. I mean, and you know, oftentimes it seems like there must be some sort of coordination going on. What are the lines there?
Well, it depends which jurisdiction you're asking about. There are different lines under federal, state, and city law. So first of all, you have to consider the statute, the regulations, and probably most importantly, the enforcement authority. So just to make it New York specific, we have a state board of elections that administers a statute that says that an expenditure is independent if it's not authorized, requested, fostered, or cooperated in by the candidate who would benefit from the expenditure. And so you would look, the State Board of Elections in implementing that, and they haven't explained it really very much beyond the statute itself, will look to see whether there was any indication that the campaign had an involvement in that type of express advocacy, you know, vote for or vote against communication. New York City, on the other hand, in its local campaign finance law administered by the City Campaign Finance Board, has detailed regulations and has a history going back many years of looking and enforcing the law to see whether there were indicia of cooperation between a candidate that benefited from an expenditure and the independent spending entity. And the tools that the City Campaign Finance Board has have been substantially enhanced by new public disclosure requirements. This is the first election in which independent spenders have been required to file disclosure statements with the City Campaign Finance Board. It's a result of a 2010 city charter referendum, and the board has adopted detailed regulations. There's been a lot of disclosure, and the board is now looking at that disclosure to see whether they can make cases that what was purportedly independent was in fact coordinated. The board conducts an audit process of every candidate who comes through the city system, whether they received public financing or not, and it's likely that there will be cases that the board will look to bring in this election to determine whether spending was coordinated. If it was coordinated, there are significant consequences. A coordinated expenditure is treated as an in-kind contribution, which means it now falls within the limited universe and contribution limits apply to it. And there are restrictions not only on the amount but the source, and so violations could be found in those types of situations.
But the CFB can't bring criminal charges against a candidate, is that correct?
No, they do, and they have in the past made referrals to prosecutorial authorities, so there's always the potential for that. I don't recall that specifically coming up in an independent spending context, but the potential is there.
And is there some sort of rules of thumb that you offer to your clients to make sure that they don't get into any trouble with independent expenditures?
Absolutely. Every campaign needs to be educated to understand what the coordination standards are and to take protective actions to ensure that no lines are crossed. And we advise our clients along those lines, and the last thing a campaign wants to do is make that type of error, which could jeopardize their public funding.
We saw with the Moreland Commission hearing about the State Board of Elections just a real dysfunction in the addressing of complaints to the board, and how oftentimes the complaints that are made, even though they may be really germane to the outcome of an election, aren't considered by the board until after the election has passed. Doesn't that kind of make it like a Swiss cheese regulations, where it's like, once I'm in office and I've won, it's like, okay, I'll pay a fine or whatever, but the damage is already done. I mean, is that a real problem with our system?
I think the Moreland Commission certainly sees it that way. I believe the State Board of Elections, that's the agency we're now talking about, is perhaps looking to adjust procedures to, bring a little bit more of oversight before the election, although whether they really address the issues to the full extent that Moreland has identified it certainly remains to be seen. But you know, what I have to say is one of the beauties of the election system is there's always another election, and you know, on the one hand, you know, people argue that there should be investigations before the election when allegations are received. It can also be very detrimental to an elected official for an investigation to be going on while they're trying to, you know, function in elective office. I mean, we've seen instances of people forced into resignation. So it's not necessarily optimal from the candidate's point of view to have these things delayed, because oftentimes it turns out to be more smoke than fire, and yet they're impugned during the time it costs them political capital in terms of ability to function in office. So in many instances, an elected official would want to see an agency that has the ability to resolve issues before the election.
So like something like John Liu's situation, right?
Well, that's a very interesting development in this cycle, and my comment on that would be that that wasn't really a resolution. It was an interim action that was a dramatic interim action that I believe his attorney described as a death penalty. Right. And my concern about that is that, yes, resolution before the election is important. Voters and candidates need clarity, but candidates also need due process. And I think the Liu so-called resolution is a non-resolution, but it had a huge impact on that campaign, and it raises some questions about the process the board follows in those kind of cases.
As you pointed out earlier, that one of the two people who brought the suit in regard to the so-called LOTA PAC was Sean McCutcheon, who is also now in a case before the Supreme Court, McCutcheon versus Federal Elections Commission. What is at play in that case, and what are the possible implications for New York State?
Well, they're very similar cases. The federal case argued before the Supreme Court recently involved, I believe Mr. McCutcheon is an Alabama businessman, and he looked to make contributions. I think they were going to be $1,776 checks written to a number of federal candidates, and when he looked to do this in the last cycle, he soon found out that the aggregate amount of those checks would bring him up against what at the time was a $46,000, now a $48,000 aggregate limit on what you're allowed to give to federal candidates in a 2-year cycle. And that's a feature of an overarching, what is now a $123,000 2-year limit for giving to federal candidates, federal PACs, and federal party committees. So the challenge was brought to this what's called an aggregate limit. And the argument that was made at the Supreme Court is that the aggregate limit is in effect a spending limit because it puts a cap on the total amount that Mr. McCutcheon could give in federal elections, and that it doesn't really serve a valid or a sufficient governmental purpose versus a First Amendment challenge. When you have a spending cap, it's in effect treated by the Supreme Court as a limitation on speech. And the purpose that the Supreme Court has identified for valid constitutional campaign finance restrictions is the curbing the potential that financing activity could corrupt or appear to corrupt an elected official.
That's the famous Buckley v. Valeo decision?
That's Buckley versus Valeo from 1976. And so McCutcheon's argument is that this aggregate cap doesn't serve a purpose of preventing corruption, because what's the difference between my bumping up against a limit where I can give to 9 candidates versus, say, 10 candidates? And the reason why this argument appears to have some strength is because federal law also has what are called base limits, limits that apply to particular candidates. So in this cycle, McCutcheon could give $2,600 per election to any particular federal candidate. It's a limit that has been upheld by the Supreme Court as a safeguard against quid pro quo corruption, which is a constitutional test for campaign finance restrictions. And the argument his attorneys make is that limit is sufficient for vindicating the constitutional interest. This overarching limit serves no valid additional purpose. The other side defends it, saying, well, there's risk that even though you can only give $2,600 to any individual candidate, there's a risk that that money could somehow be pooled and used to circumvent the limits. So that's really the question in the national McCutcheon case as to whether the state's interest in providing an aggregate limit as a safeguard against circumvention is sufficient for constitutional purposes, or whether the court will say, look, the base limit is as far as the government can go in restricting contributions in a federal election. To bring this back to New York, the Supreme Court has spoken very clearly that when it's issuing First Amendment rulings in federal election cases like Citizens United, that those rulings, the jurisprudence applies at the state level. So we get back to this $150,000 limit that we discussed before. The case in New York, the Laufer case, is what we call as lawyers an as-applied challenge. So it says that that $150,000 limit can't be constitutionally applied to a super PAC, a PAC that's engaged in independent spending. The national McCutcheon case takes that one step further and says this is a facial challenge to aggregate limits. So if the McCutcheon challenge succeeds at the federal level, I think the ramification in New York is that $150,000 limit would likely fall altogether, which would free up individuals to give to an unlimited number of candidates, party committees, and PACs in New York without an overall $150,000 aggregate limit.
One of the things that I've read some experts say is that it's possible that if the aggregate limit is struck down, that could also undermine the individual limits that could be given to candidates ultimately. Do you think that there's merit to that? And if so, I mean, could we see it's one of the cornerstones of the New York City Campaign Finance Board system is the fact that there is a limit, right? And if those limits cease to exist, would that kind of undermine the whole system?
Well, I think that's essentially the circumvention concern, which is on the other side of the McCutcheon case. Certainly, once aggregate limits are removed, there's one barrier to circumvention that comes down. There are other tools that campaign finance laws feature, like anti-earmarking rules, for example, or restrictions on transfers that are other ways to try to get at the risk that money could be funneled around those base limits. Some of the risk in New York is ameliorated by the fact that New York sets very high contribution limits for under state law and for statewide offices. So the incentive to get around those limits is kind of limited by the fact that the limits are high to begin with, and there are other techniques that are used under New York law that are seen as evasive of the limits, like unlimited housekeeping accounts and the ability of multiple LLCs to give up to the limits. So I'm not sure what the real-world impact would be of the removal of the $150,000 cap. People have been able to engage in activity without that really being effective as an effective restriction against circumvention. But on a theoretical sense, it would be pretty significant, because if you have lower contribution limits, where, like you do in New York City, then there is an incentive that exists for circumvention, potentially. And the flip side of that is you no longer have an overarching ceiling.
You are the former general counsel to the New York City Campaign Finance Board, and we have heard, in recent years, a lot of talk about implementing some sort of campaign finance board on the state level. And in most instances, we've heard that it would be modeled on the New York City system. What are lessons that state lawmakers could take from either the deficiencies or the strengths of the New York City CFB in order to build a better system on the state level?
Well, my own view is the city system is a good starting point for crafting a state system. However, it needs to be very closely studied. There are, for example, we have a 2-year legislative election cycle for state offices, and we have an audit process in New York City that goes on 3, 4, 5 years. So you can have audits straddling, multiple election cycles for state officials, and which brings us back to the issue of the need for resolution and clarity before the election, and it can become a drain. What we wouldn't want to see, I think, is replicating the compliance burdens that exist in the city system. It's hard to qualify for matching funds, and I think that's appropriate. But whether it's unduly hard is one of the issues that should be looked at. So in terms of the burden of qualification, the burden of demonstrating compliance, how can that be streamlined to fit within a 2-year cycle? One of the things that might be considered, as they try to figure out something that would be politically palatable to both parties, would be whether there could be a phase-in. We're talking about,
like just starting with the controller's race?
Well, the controller's race is one proposal, or perhaps statewide before going to the legislature, or in some jurisdictions, New Jersey, for example, there were pilot programs for certain legislative races with a public financing element. All those are techniques to try things out. Whether you can really apply it to 213 legislative offices and 4 statewide offices, and implement it all in one election simultaneously. That's 4 times the size of the number of offices covered by the city system, which has been operating for 25 years to try to get the kinks out. And believe me, there are still kinks in it after 25 years. So to try to develop something that's really going to fire on all cylinders first election statewide is an enormous challenge. And the flip side of it is, as anxious as the advocates are to have something adopted into law, you don't want something adopted that's going to flop and undermine the case for this type of reform permanently.
I've heard some lawmakers say that rather than looking to New York City's system, maybe we should look to Connecticut's system. I mean, are there any other states or municipalities that have really an exemplary approach to campaign finance?
Well, Connecticut's system is largely modeled on the city system. Connecticut, state of Maine, Arizona, these are the prominent large public financing jurisdictions. I believe Minnesota and Wisconsin have programs. There are municipal programs, Los Angeles, which I think is also modeled on the city system. I think there are lessons that can probably be learned from all of these jurisdictions. I think, once there's any kind of consensus, which of course is a big logical leap, any kind of consensus for reform, then we really need to turn to the practicalities and not just adopt something that looks perfect on paper and really does turn out to be the enemy of the good.
Citizens United, McCutcheon, and it seems like some other cases that could be coming up through the pipeline are clearly aimed squarely at striking down campaign finance board systems, right, or campaign finance systems. Is it a possibility that because of the Supreme Court decisions that there will no longer be a legal area within which campaign finance systems can operate, or is there some sort of like opt-in approach that would make it not be governed by the federal law?
Well, I think Citizens United and the cases that are based on those theories are weakening campaign finance systems that don't have a public financing element, that they are weakening systems that are rely entirely on the notion of limitations, because these cases have been bringing down limitations. So what they don't bring down are disclosure laws. Disclosure laws have been attacked strenuously after Citizens United and mostly upheld. And so you can have a disclosure-based system, and to a large degree they haven't brought down public financing systems. So to the extent that regulators want to invest in an area where they can continue to have some control over the financing, public financing is actually more attractive in light of Citizens United. And another reform that we've seen a lot, for example, in New Jersey, is what's called pay-to-play, which has a parallel to public financing, because this is the ability to apply campaign finance restrictions to individuals who are seeking business from a government. So pay-to-play laws, which really don't exist yet in New York State, is another avenue that might be developed as general limitations are more restricted by the Supreme Court.
Lastly, there are very few practitioners of election law, right? And it's of this kind of arcane science that is very perplexing and filled with minutiae. How can a candidate pick a good election law attorney? What kind of criteria should they be looking at to know that they're going with someone who's actually really capable?
Well, I can give my phone number, but putting that aside, I mean, experience is very important. I think some people have said, well, Laufer wrote the law in New York City, and therefore that's the reason why people hire him. I know in my case, what really is a more significant factor is actually practicing in the area, representing candidates. We have election lawyers who come from a variety of sources. A lot of them come out of partisan politics. We have Democratic and Republican. And it's, you build a track record of the quality of work you do. You need people who, understand that, understand the regulators. So some people do come out of a regulatory background that I came out of, similar to what I came out of. But, there's a lot of attention to detail. This is not something where you can leave things to chance, and you have to have somebody who, can see the entire process, because it doesn't end on Election Day. A lot of the enforcement aspects of this go on for months and years after the election, and whereas a campaign, it has a short season and it shuts down generally with the election and people disperse. Your election lawyer may be the last person who is actually working for the campaign, again, months and years after the election. So the good situations are when we've been the first hired, which is often the case, and then we're the last one standing in terms of servicing the candidates committee.
Certainly best for billable hours, right?
Well, yes, it's that, but it's much more than that. I have a passion for what I do that goes beyond any kind of compensation that's associated with it.
Laurence Laufer, thank you so much for joining us.
Thank you.
And that's it for this episode of Last Look. For more episodes, please join us on the web at cityandstateny.com.